Senators. Senator Pizzo, you are recognized to explain the bill.
Thank you, Mr. Chair. And with your leave, I would like to, if I may, distribute the most recent information I have, just to follow along for a presentation, if I may.
All right. All right, you are recognized to explain the bill.
Thank you. By number of words, Senate Bill 656 merely is an exception under 90115, where law enforcement has probable cause to believe that the underlying statute of 790.22 has been violated. But in practical terms, this requires obviously some explanation because of the implications or possible implications of this bill. The reason why I filed this bill, and it's before you on the chart, the very first page that you have, is I would like to draw attention to the very real fact and principally why I ran for this position. Every Tuesday at 6:30 at the Northside Police Station of Miami-Dade Police Department, anywhere from 12 to 20 mothers of murdered children meet to discuss their kids' cases and really come together as a group. On any given day, if you ask by a show of hands how many arrests or closures have been made or the clearance rate for those murders, maybe one or two hands go up. Overwhelmingly, members, the victims of homicide by firearm are black. And we don't march and we don't rally on behalf of black and brown children at all. But year over year in Miami-Dade County, selfishly, over 17 kids, 18 and under, die from firearms. That's more than was killed at Marjorie Stoneman Douglas. I've also, in that chart that you see before you, you'll notice that the race of youth homicide victims ages 15 to 17 killed by firearm nears 80% for black children from 2007 through 2017. The trend is the same for 2018, hasn't been updated by FDLE yet. Also, you'll notice that 70% of 12 to 14-year-olds and 87% of 15 to 7-year-olds, if it's by homicide, they're black. The disturbing trend, but it's the reality, is that overwhelmingly white students, white youth, are killed from 8:30 a.m. until 3 p.m. Black kids are killed from 4 p.m. through 2 a.m. The highest number of homicides in the state of Florida, in all of our districts, collectively, are black and brown children. And while we have special sessions and spend hundreds of millions of dollars and debate and discuss all types of things in all manners, I appeal really to your sense of fairness and justice in the community that if we want to tackle the gun violence problem, we should pick the largest pool of kids getting killed. And in my district, overwhelmingly, every year, it's young black men. And we have done little, and nor should you know so much about this really because it doesn't have the attendant attention that a lot of other things get. But if we want to escape the partisan positions of background checks and gun show loopholes and a number of things that don't apply to 13 and 14-year-olds, and we want to pick the low-hanging fruit to save kids' lives, it would be this exception. Included also in your packet in the very last page is a letter from FOP Director Al Palacio, who's also a lieutenant with the Miami-Dade School Police Board. And here's the practical issue. It is per se illegal for a 13, 14, or 15-year-old to possess a firearm, unless they are target shooting at a competition or they are hunting, which is an exception in 790.22 that I do not wish to disturb or touch. I have no implications in my bill, either subtly or directly, that have any effect on anyone's Second Amendment right as recognized by this legislature for many, many years. 790.22 is the bill that the wisdom of the prior legislature has enacted that's been on the books for many years. But if you look in the staff analysis, in the Senate staff analysis, in the case of TM versus State on page 2 of the staff analysis, the judge, referring to section 790.22, stated, quote, 790.22 was designed to get the immediate attention of all juveniles and to issue a wake-up call that the state deems their firearm offenses to be serious enough to warrant the automatic deprivation of liberty for a period of time, even on first offense. That ruling was issued in 1997. None of you had Facebook, Instagram, TikTok, Snapchat, any of those things. Technology, in a weird perversion of justice, has been able to outpace the reality of how we demonstrate, but more importantly, how we communicate. As a father of 13-year-old identical twin boys, they're on Instagram, they're on Facebook, they're on Snapchat, And that's how they communicate with their peers, by impression, directly or indirectly. That's where they gather their information, unfortunately. When we were kids, if you wanted to demonstrate or display something or advertise it, you either took out an ad in the paper or you wrote a letter. But threats, even subtle ones today, are demonstrated based on vulgarity, obscenity, or threats to children over social media. We have a very, very serious limitation here. If my child, Jack or Julian, writes 5 words, "I'm going to shoot somebody," SWAT will be at my house in 15 minutes. And yet, again, in some weird permutation of technologies outpacing, we can have an individual who loads a firearm, racks it, shoots it off in the middle of the street, and because of the present condition of 790.22 being a misdemeanor, the police can't do anything about it. Because, as you know, all misdemeanors, with 16 exceptions, require the officer presence rule. We have exceptions for battery and for assault, and for last year, this legislature, of which I also voted on yes under 316.191, we created an exception for racing. So if Senator Hudson videotapes me racing out of here and gets my tag and is able to identify me through law enforcement, I could be arrested. While it's a misdemeanor typically, and prior to last year, an officer would have to be present. And yet, this is what I'm saying, and what I'm telling you, is that very often, I would be in a courtroom in my prior profession, and some young man would be charged with the attempted murder or the murder of another minor. And there, I had no difficulty asking the judge if I might show the mother or father or grandparent who was there enraged that their son or daughter had been charged with this, and I would ask them to show a photograph. And with leave of the court, I would ask them if they could identify a particular place. And they would say, yes, that's my living room, or that's the front of my house. The second picture might be a picture of their son or daughter holding an AK-47 or a loaded Kel-Tec or a Glock with 30 mags in it. But that was too late, folks. What I mean by that is at that point, someone's been shot or killed. So one family is suffering a loss. And the mother, grandmother, grandfather of the other family is about to lose their child as well to the system. What I'd like to be able to do is give law enforcement the ability to intervene before there's a body, to be able to knock on the door and cast investigation. The elements of any particular crime, no matter how small or how large, require that the satisfaction of elements be there for an officer to make an arrest. Within the 4 corners of the A-form, the elements of whatever particular crime it is must be satisfied. There are 2 others that no one ever talks about that are very important to this bill. You must prove ID, identification, and you must also prove venue. So, in the abstract, for those who have concerns about, well, that's just a picture that was taken and you don't know when it was or what have you. The remedy and the recourse for that, evidentiarily speaking, is that photographs, whether you know it or not, you can go on your laptop right now, and if you go to your Facebook page, you can right-click it, and the metadata will show you the device and the GPS coordinates and when it was taken. That's embedded metadata. And I apologize if I'm sort of in debate now, but
That's more than,
I apologize.
But that's okay, because you know what? You've explained the bill.
Okay.
You've made your closing argument, and you've also explained the amendment, and that is okay.
I have a little bit of passion about it.
Well, and that is fine. Senators, there is one amendment, and that amendment is barcode 220438. It's timely filed by Senator Pizzo. Senator Pizzo, briefly explain the amendment.
Mr. Chair, the amendment is technical in nature but important in application, and we are basically saying there's probable cause to believe that the person is a minor who has committed the criminal act.
Under 790.
Under 790.22, yes.
Which deals with the minors.
Correct.
All right, so, Senators, any questions? Any question? Yes, you're recognized.
Could you tell me what the bill does?
Yes. Right now, a law enforcement officer receives, a mother comes into the police station and says, this 13-year-old kid that's in school with my kid was racking and displaying a firearm in the school bathroom or on the street, or my kid has to walk by this kid's house every day and he brags about it. In private communications, if I text you something, Senator Baxley, that's a private communication between you and I. If I accept you and I have a closed social media account, that's protected, that's communication between you and I, and you accept it tacitly by accepting the friend request. But in an open public forum where anyone can see, if I can go on my phone right now, and if I had leave of the chair to do so, I could right now readily in 10 seconds show you a 15-year-old who's got a loaded firearm in a street in Miami-Dade County. It would allow law enforcement to investigate and determine whether or not that person is in fact by ID a minor in possession of a firearm, and it's per se illegal. And I just want to be clear about some things here that may get lost. it's that weird perversion of justice that I call it, because any non-felon can walk into this Senate building right now in this committee room and have a firearm. That's not illegal. But it's per se illegal if my 13-year-old son were here with a firearm. And in some weird permutation, he's allowed to display that. It's somehow sterilized by being in a public forum when thousands of other kids are seeing that same thing. It would allow police to investigate that particular possession.
All right, yeah, any other questions? Any other questions? Okay. Now, we are on the amendment, barcode 220438, and I do not see any appearance forms on the amendment. Any debate? Seeing no debate, Senator Pizzo waives his close. Is there any objection to taking up amendment and favorably adopting amendment barcode 220438? Any objection? See no objection. We are now back on the bill as amended. And Senators, any further questions? All right. We're back on the bill as amended. We have two appearance forms. The first appearance form is from Lieutenant Michael Crabb, who's waving in support. Is that correct? All right. The next is Lisa Henning, who is Legislative Director for the Fraternal Order of Police, speaking for. Is that correct?
Yes, sir. If there are questions, otherwise, I think this testimony
All,
covers everything.
all right. Thank you. All right. In favor of the bill as amended. Senators, any debate? Any debate? Yes, Senator Hudson, you are recognized.
Thank you, Chairman. And if the sponsor could just repeat, I think you said that there's exemptions for children that are out in the fields hunting. If you could just say that in your close and maybe clarify that for me.
Sure.
Thank you.
All right. Any other debate? Any other debate? Seeing no further debate, Senator Pizzo, recognized for a very, very brief closing,
Very
like
brief,
30
if I may.
seconds.
If I may.
Yeah.
790.22 has been on the books for years, and it's very clear, and a lot of the concerns were surrounding around target shooting and hunting or lawful activities. I want to be very clear. The Second Amendment right of a child is very distinct in 790.22. If you want to take your kid hunting, target shooting competition, have at it. But the law is very clear that in the transportation between your home and that place, you're not letting your 13-year-old with a loaded firearm in the front seat. When I said per se, I saw some eyes go up. I just want to be very clear. Unless you are hunting, supervised with a guardian or a supervisor or coach, or target shooting, it is per se, it is strictly illegal for a 13-year-old to be right outside on the plaza right now with a firearm, okay? The evidentiary standard, which must be overcome by law enforcement, is very, very high. There's no tie goes to the runner, there's no maybe. This is pure, distinctly open and notorious possession of firearms in places where kids in my community get killed every single day.
All right. Senator Pizzo, having closed on CS for SB 656 as amended, Madam Secretary, would you please call the roll?
Senator Baxley? Yes. Senator Gibson? Yes. Senator Hudson? Yes. Senator Starger? Yes. Vice Chair Rodriguez? Yes. Chair Simmons?
Yes, and Senators, by your vote, CS for SB 656 is reported favorably.
Thank you, sir.
You're welcome. And